It doesn't matter what year you are. I'm head of the associates. If I give you an assignment, you do it.
Hey, everybody. This is your daily dose of all things royal. Welcome back, my gorgeous, good looking friends. So, it appears the US government is being quite difficult at the moment with the Heritage Foundation. So, dates are going to be really important on this. So, on May 10th, the Heritage Foundation submitted a filing for a preliminary injunction. In simple terms, a preliminary injunction is temporary relief that preserves the status quo until the courts decide on the merits of the case. So, what this is doing is asking for the process by Homeland Security to continue to keep them in the expedited queue in that submission that they made in requesting these documents on Harry's visa. From what I gather, it's the whole point of Homeland Security dragging their feet and the time it's taking to turn around these documents. And the argument by the Heritage Foundation states that this preliminary injunction is to enforce the timing provisions of the FOIA expedited processing provisions. So they say they believe they have a clear likelihood of success on the merits. And they also said that they have presented overwhelming evidence that the request concerns a matter of widespread and exceptional media interest. So there's a lot of interest in getting this turned around quickly because there's a lot of stuff that is going on within our government at the moment. And this actually is something that is important considering we do have a challenge right now with our borders and homeland security, as well as the corruption that is being uncovered within the various departments within the US government. Anyhow, as part of the joint status meeting, there was a due date of May 26 for Homeland Security to respond back. And this is the motion in opposition for this preliminary injunction. So Shari Suzuki is the appeals officer who works in DHS overseeing this operation. And she makes a declaration here on the events that transpired with this case. So, according to the timeline of events, on March 8th, Mike Howell submitted a request to the Department of Homeland Security, Border Protection, and U.S. Citizen and Immigration Services to get information around Harry's visa and the information that was included on his application. Well, this office was quick to turn around and close out the case, citing they had insufficient data because the Heritage Foundation did not provide authorization showing that Harry, the Duke of Sussex, gave authorization to release the information. So, this next statement sounds kind of stupid. So, Border Patrol also stated that due to privacy, Border Patrol cannot confirm nor deny the existence of records on this individual or business. Are you kidding me? You mean to tell me that we're not allowed to know that this person, Prince Harry, a UK prince on American soil who's interfering with our government, the public is not allowed to know whether or not this person on US soil is here legally? To me, that sounds kind of dangerous, especially if they're doing this with many other people who are just coming into this country and squatting. So let me get this straight. Border Patrol cannot confirm whether they have any records on Prince Harry, or for the matter, anybody coming into this country. Well, that doesn't make me feel safe. I would expect that every foreigner on US soil be documented. 1000%, even if just having their name on a file or record. But this indicates that there is room for having people not registered. And maybe Prince Harry is not registered and he's just over here. Maybe he didn't even fill out an application. Has anybody thought about that? Then on March 15th, Heritage Foundation refiled again, submitting additional documentation indicating why they feel entitled to have this information based on public interest. And they cited all the places where Harry admitted to using drugs. So now, approximately 3 weeks later, on April 5th, Heritage submits again a request now to expedite this request. Then a week later, Border Patrol then contacted the Heritage Foundation asking to provide or to resubmit the same attachments that had been already submitted. So 2 weeks go by, no response, no updates, no progress, nothing. So Heritage is pissed off and they file this lawsuit on May 1st, kicking off getting the attention of the government now. Now, this to me seems like some kind of cover your ass bullshit. So on May 23rd, Border Patrol finally gets to the Heritage Foundation's case and gives them back a determination stating that they have closed it because the request is insufficient and they neither can confirm or deny the existence of records related to the Duke of Sussex, as doing so would betray the privacy interest protected by exemptions, and that's according to law. Now, in my opinion, being that this was signed on May 25th and then the due date for this submission was on May 26th, I believe that they wanted to get this off the table. And this is what happened. Let's take a look at the response that they gave back to Mike Howell, because the Department of Homeland Security included it in this filing. So here is the letter. Dear Mr. Howell, and as you can see, they're replying to his request and appeal. Now, in this document that they provided here, it highlights all the forms that should be accompanying with this if you are looking at someone who's coming into this country, what the proper documentation would be in order to approve allowing somebody here to stay without being a citizen. So we're looking at all of this, and so they go through and summarize what was requested from the very first request, then to the appeal, and exactly the position that the Heritage Foundation was taking as to why they didn't have some of those forms and it being of public interest. So it says in this paragraph, the FOIA division indicated that your FOIA request was reviewed as a third-party request and did not include authorization that information for the Duke of Sussex could be released to you. The FOIA division asserted that all third-party FOIA requests must include a signed G28 or G639 form or a signed statement from the subject individual verifying that his or her information may be released to you. Furthermore, they indicated that due to privacy concerns, Border Patrol could neither confirm nor deny the existence of records concerning this individual. Therefore, your FOIA request was closed as insufficient and no search for records was performed. Finally, you argue that a third-party release is not necessary for this request because there is an overwhelming countervailing public interest in the disclosure. And they argue that the public confidence in the government would undoubtedly suffer if DHS, Border Patrol, and USCIS failed to properly vet such a high-profile case. Moreover, you argue that if the Duke of Sussex was granted preferential treatment, that too would undermine public confidence in DHS, Border Patrol, and USCIS application of equal justice under the law. So now they give a determination on the case or the appeal now. This is what they said. So they start off with the appeal determination and they talk about the purpose of the Freedom of Information Act and how it plays in society and its democratic process and blah, blah, blah. They continue and say, at the outset, we observe that FOIA division denied your request on two separate grounds. First, that you failed to provide authorization from the Duke of Sussex, allowing for the release of agency records concerning him to you. And second, that even acknowledging the existence of records would infringe upon his privacy. Okay, so they're reiterating their position that they have stated from the very beginning. But then they continue to hold firm that the Duke of Sussex needed to authorize the release of this information. And it says nothing in the submission you have provided indicates verification that the Duke of Sussex has consented to disclosure of his records to you. We therefore find that FOIA division appropriately closed your request as insufficient on the basis that it used its administrative discretion to require additional information to verify that the Duke of Sussex has consented to disclosure of his Border Patrol records. So they're holding firm. Look, you didn't get the thumbs up from Harry, so we're going to protect him. That's what this essentially says. So technically, they're back to square one, but they continue. We affirm the FOIA Division's second grounds for denial that the agency can neither confirm nor deny the existence of records related to the Duke of Sussex, as doing so would betray the privacy protected by exemptions and the law. Merely acknowledging the existence of those records would itself cause harm cognizable. This stands as an exception to the general rule that agencies must acknowledge the existence of information responsive to a FOIA request and provide specific, non-conclusory justifications for withholding that information. Both exemptions relate to protecting personal privacy and have been invoked here only to protect personally identifying information of the Duke of Sussex, who would be identified as mentioned in the Border Patrol records, if any exists. If any exists. So there is a possibility that Harry is here in the United States undocumented. Now that's some bullshit, in my opinion. I think the American people have the right to know if foreigners that are here, the proper paperwork has been filed. That's our safety and our security that they're messing with our tax money. This is so scary to me, as we have thousands coming into this country on a daily basis, and we're not allowed to know if these people are documented or not. What kind of show are they running here? This is infuriating. It says, to determine whether this information ought to be withheld under the exemption, an agency must first determine whether the exemption threshold has been met, and if it has, then must balance the privacy interests involved against the public interests in disclosure. In this case, simply identifying whether records you seek exist confirms that the Duke of Sussex applied for entry into the United States and therefore was inspected by Border Control. The records from the systems you requested would provide any history of the Duke of Sussex travel to and from the United States, as well as any potential Border Patrol violation he may have incurred. Oh, really? This, in and of itself, would be a violation of his privacy interests. So it is possible that Border Patrol could have found some weed, some shrooms, kilo of coke, but they'll just keep it between them and all is okay and still allow him back into this country. Good to know. And continuing on, shooting down public interest because who cares what the Americans think? Who cares about the people who are paying these people's salaries? Says not all assertions of public interest under exemptions 6 and 7 are legitimately entitled to any real weight in the balancing process. Wow. Continues on and it says a bare suspicion of agency misconduct is insufficient. A FOIA requester must produce evidence that would warrant a belief by a reasonable person that alleged government impropriety might have occurred. An allegation of public interest that is nothing more than a general public curiosity in the subject matter of requested records is legally insufficient. So forget what the people think. We're going to do what we want to do, and I'm sure Harry is laughing at all of us. Now it says you submitted a significantly large number of articles concerning behavior that describe activities that could result in the Duke of Sussex facing heightened scrutiny at the border. Yeah, and? You therefore argue the Duke of Sussex travel and inspection records should be released to the public to determine if he was granted preferential treatment because such treatment would undermine public confidence in DHS, Border Patrol, and USCIS application of equal justice under the law. Well, I thought that they were originally asking for this application to see if he lied on it because he's admitting to doing drugs. I feel like they're missing the point here. So, this next paragraph is interesting. It says all persons, baggage, and merchandise arriving in the customs territory of the United States from places outside thereof are liable to inspection by a Border Patrol officer. Unless exempt by diplomatic status, all persons entering the United States, including U.S. citizens, are subject to examination and search by Border Patrol officers. Border Patrol officers must determine the nationality of each applicant for admission and, if determined to be a non-citizen, whether or not the applicant meets the requirements of the Immigration and Nationality Act for admission of the United States. Well, that's all fine and dandy, but we'll never know any of that because they're not allowed to release any information. So how are we to know if Harry has diplomatic status or not, or if he's here and people are just looking the other way because of who his family is? We'll never know. So what's the point of putting that paragraph in? And finally, this paragraph at the bottom here, it says, furthermore, information that may have subjected a traveler to additional scrutiny at one time has the possibility of being considered untimely and irrelevant at a later date. Given these facts, the result of one person's Border Patrol inspections, even a famous person, is insufficient evidence to undermine public confidence in Border Patrol and its application of equal justice under the law. As such, we find that you have not provided sufficient public interest to outweigh the Duke of Sussex right to privacy concerning any potential Border Patrol records about him that may or may not exist. And why the F not? Help me understand why the American people cannot know if this prince of the UK is here in the United States legally. I think we have the right to know this, considering he has been actively involved in our government policies, openly talking about drugs and influencing our youth. They seem more concerned about the integrity of the department than actually understanding that this is a security threat. And we're supposed to sit back and think that they're doing their jobs 100% perfectly when we see what's happening across the border. We've got people coming in and we can't find out whether or not they have a history of killing anybody or smuggling drugs or carrying in firearms. We can't ask any questions because we got to respect their privacy. Personally, I think the mandate to get authorization from a person to release records to the public is kind of crazy, because who in their right mind would say, yeah, go ahead and release all my personal details to the public? In this case, I do think that the Heritage Foundation gave a good reason as to why the public must know. I think this is super important to know because he has confessed to be taking all these kinds of drugs. And at the same time, he had been interfering with our government policies in working with Aspen Institute. So this bill, introduced into the Senate by Mr. Michael Bennet of Colorado, Democrat, also very connected to the Aspen Institute. So this bill that Senator Bennet wants to push through is all about creating a new federal agency that essentially is online police. And their power would be able to launch investigations and penalize people, whether it be via monetary or even jail time. Now, in looking through this, the scary thing about this is that it's giving the government full access to every social media and website that operates inside the United States. So there are 7 things that this agency that they're proposing under the executive branch would be responsible for. And that would be access to digital platforms for civic engagement and economic and educational opportunities, access to government services and public safety, competition and consumer welfare, such as lower prices and better quality of service, prevention of harmful levels of concentration of private power over critical digital infrastructure. You notice they use the word private power, meaning us little people. So if there is a whole group of us that feel a certain way, they don't want us congregating together if it doesn't align with whether it be the agenda that is being pushed. That's some scary stuff. Then they have a robust and competitive marketplace of ideas. Okay. Protection for consumers from deceptive, unfair, unjust, unreasonable, or abusive practices committed by digital platforms, aka your opinions, if it doesn't align with what people feel or whoever is on that committee. And then assurance that the algorithmic processes of digital platforms are fair, transparent, and safe. Why do I feel like I've seen this before? Oh, right. We've all seen it before in the Aspen Digital report that Harry was a commissioner for. This is 100% an assault on freedom of speech. That's your freedom of expression, your freedom of thought. And I think what's scary about all of this is you put a governance setup like this, and let's say you express yourself, and this group doesn't like this expression because it's not part of the agenda, and they flip it around on you and call it hate speech. Now, all of a sudden, you have been penalized, whether it be this new behavioral code. Yes, they're talking about giving codes to people, or fining you and possibly even putting you in jail for just expressing something. This is very dangerous, and it concerns me that this is going to be pushed through before the 2024 elections in order to then clamp down on anyone who doesn't fall in line and does not like what is going on right now in the current administration, as well as what is happening in our world today, especially if you're American, what we're seeing going on, utter chaos, and we want change. This Aspen Digital Institute report that Harry was a part of is definitely the foundation for this bill. And if you look through both of the documents, you will see that it mirrors the recommendations that this report had created back in 2021. I am angry in seeing this because now we have this UK prince who contributed to this and has been very vocal about suppressing the British media and going after them. So him being here and having a part in legislation that's going to drive what the rest of the world is going to do is a serious thing. And it's why the Heritage Foundation needs to get it together and get that information, because he needs to go.
The federal government, from Democrat members of Congress to intelligence agencies, including the FBI, used Twitter and other social media companies to censor Americans' speech. If the alarm bells are not going off, then you're not paying attention. Over the past 3 years, documents show, they prove what you guys have uncovered here, is there's communication between Twitter and the FBI. It was constant, it was pervasive. Twitter was basically an FBI subsidiary before Elon Musk took it over. The Twitter files revealed that by 2020, Twitter was engaged in open information sharing with the intelligence community, and now we know there were many intelligence agencies apparently involved in this. The FBI pressured Twitter to act on election-related tweets leading up to the 2022 election. Of course, they did it in 2020 as well, and Twitter dutifully censored content as a result. Twitter executives restricted accounts. They censored speech that conflicted with the left's narrative. Twitter has used its internal tools to control and manipulate speech considered misinformation, and who was determining that? It was the government bureaucrats. Documents show that Twitter used visibility filtering to restrict certain accounts and posts and removed people from the platform altogether. The Twitter files should be a matter of bipartisan concern for every member of Congress and every American citizen, because it is a bedrock principle of our constitutional system that the government does not get to decide what speech is acceptable or true. Under the First Amendment, Americans have a right to speak freely, regardless of whether their speech upsets the preferred narrative. In fact, that's when it needs the most vigorous protection. Everybody on the left used to believe in that, or at least they purported to. Government and media fact checkers frequently get things wrong. The American people can't and shouldn't rely on so-called experts to be the arbiters of truth, disinformation boards and the like.
Let's not forget that Aspen Institute and this report was exposed in the Twitter files by Matt Taibbi in Twitter censoring Americans online. This is indicative of clearly this is what they're trying to accomplish. And honestly, I think Harry needs to be sued by the American people. And that's just my opinion that I have the right to voice, as well as comment on things and even criticize, as those are fundamental rights that are guaranteed by the First Amendment.
The First Amendment and an American population accustomed to the right to speak is the best defense left against the censorship industrial complex. If the latter can knock over our first and most important constitutional guarantee, these groups will have no serious opponent left anywhere. If there's anything the Twitter files show, it's that we're in danger of losing this most precious right, without which all democratic rights are impossible.
This is getting serious, and now you see the chilling effects of what Prince Harry is doing and why he needs to be stopped and why he needs to go. What do you guys think? Leave your thoughts below. As always, I will be back with more content, but until then, please be safe, and I will talk to you later. Bye!
That was such a fraud.